actually, and talk about. There's a recent Rumble video with General Flynn, and where he talks about fifth generation warfare and what people have to be considering when they listen to these podcasts. There's a lot of disinformation out there, and if you understand about fifth generation warfare, they want you to know they don't want you to know what the truth is, and so they put lots of disinformation out there. And when you circulate it, if you're a trusted source, then you give it validity by circulating it. And so we all have to be. Anyways, I thought it would be better coming from them, but I've got about an hour-long podcast with General Flynn that I think would be useful. That would be one thing we could talk about. Or we could talk about, the recent court filings. Matter of fact, they keep this, the Texas Attorney General keeps coming in and wanting to defend these judges that I'm suing in their private capacity. And so, I keep going back and wanting them to strike it because they don't have standing. And the judge hasn't done anything yet, hasn't made any rulings yet. But I consider that positive, because if he was going to strike it, he would have. If he was going to dismiss, the Attorney General wants to get like the Chief Judge of the Supreme Court dismissed off the case. And I sued these two judges in their private capacity, and the Attorney General wants them off the case. And who else? The Texas, the Director of Public Safety, they want him off the case. Who else is the Attorney General? The Chief Judge of the Supreme Court. Oh, and I also added I filed a second amended demand for relief, and the argument was that there's an emerging dictatorship in Texas. I could go through that brief if you want. That's another thing I can do, is go through the brief that I filed about the emerging dictatorship in Texas and why it's an emerging dictatorship.
That sounds good, but we should do the Bivens and start up the meeting with the Bivens, the private meeting
Sure.
Information, okay?
Yep, sounds good.
Have we done an order to show cause for your motion? Why it should not be granted? Or?
What I'm thinking about doing is I did a motion to strike, a motion to deny, and a motion to strike, and a motion for sanctions. But actually, I'm thinking that it's been 21 days, and so I ought to do a motion for a default judgment. Anyways, I was talking to Randy Kelton here recently, and that's what he suggested. So he's been right on the money when he tells me to do something. He's pretty sharp. Anyways, Lori, why don't you do the Bivens?
Yeah, I'm just pulling it up now.
So, Glenn, you're saying she's doing a Biven? You're doing a Bivens in this?
Well, no, Lori does a Bivens for this conference call right now because to make sure that there's not going to be anybody on here that's going to cause problems.
I understand, because I had conflated that with you suing the judge in the private capacity, and I don't know how they would, how the Attorney General could come in on their behalf in their private capacity.
Well, that's the question, isn't it? They keep trying, and I keep telling the judge that they don't have standing, and plus, I'm the king, okay? Will Livingston's my fourth great uncle, which means I'm posterity is found in the Constitution, and I have right of blood, which means that no civil law can violate right of blood, and which all the Texas laws and all the laws of Congress are civil laws. And then that which is created can never be greater than that which created it. And the Supreme Court even agreed. And there's court cases I put in there basically saying the same thing. So the Attorney General is supposed to be representing me, is who he's supposed to be representing.
Yeah, I agree.
And so he's perjuring his oath. And
so put him on the suit. He's another real party in interest.
Exactly. That's what that's my second amended demand for relief. I'm adding the Attorney General. But the judge hasn't granted me leave to file it yet. I had to do a motion because the first one is a freebie. I can go ahead and do the first one free under their rules. But the second one, the judge already told me that I had to file a motion to do the second one. So I took it as an opportunity to make a second one, which I did. And then I filed it all together, but he wanted me to do a conference with all of the other counsel and ask them if they approved or disapproved of it. And they all disapproved. The Montague County, the bar members for Montague County, they were kind of, nasty when I talked to them, but they said that they disapproved of it. They didn't even want to know what I was trying to do. They just disapproved anyways. You know what I mean? But the Attorney General that I'm dealing with, he was actually pretty nice. He wanted to know what issues I was going to bring up, and that's what. Oh, I got some echo.
Wild horse. Stop sharing. Glenn, have you thought about doing a Rule 27 preservation of testimony?
I'm not sure what that is.
Rule 27.
Yeah, I don't like to bring up their rules too much because they bring it up, but I don't like to bring up their rules. Because again, I'm the king. But I'll mention the stuff that's mentioned in their rules. But what's Rule 27? What exactly is that? Preservation of testimony.
Yep.
I'll have to look that up. That sounds interesting. So I want to preserve their testimony against them. Is that what you're saying?
Yeah, it would be like a deposition. Depositions are testimony. Yeah.
Yeah, that's a good idea. That's not a bad idea. That lets them know, gives them a heads up that I'm using this against them.
Hey, Glenn.
Yeah.
We have to play it. We have a pre-recording of the Bevins that Wild Horse has the ability with her device on her end to play it and share screen at the same time, where I do not. So that's what we're going to do right now. Okay? Just want to give you a heads up. Okay.
No problem. I appreciate it. And some reason when you had that logo up there, I had some feedback and echo. Do I need to mute myself?
Yeah, everybody needs to mute while Wild Horse plays that. Yeah, that would be good.
Okay. I'm muting myself now.
The Biven Statement. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at today's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? The Biven Statement. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at today's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? The Biven Statement. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at today's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present?
Awesome. Thank you, Wild Horse. We're going to work on getting that right sooner or later. Go ahead, Glenn. Take it away. Give us some good info tonight.
Okay, I'm just gonna, whoops, I gotta open up that file.
Glenn, while you're doing that, you went into a document where you parsed out United States of America. Do you remember what that document was called?
I'm not sure what you're talking about.
Okay.
Parsed out United States of America?
Yeah, you did a deep dive. It's a couple of months ago.
Well, I can tell you that there's the United States of America. There's the Constitution for the United States of America. There's the Constitution of the United States of America. And the one that I like to use is the way it's described in the preamble.
There's also United States of go ahead.
Which is this Constitution for the United States of America.
There's also United States of America under the Treaty of Ghent between His Britannic Majesty and the United States, and small v. United States of America under the Treaty of Ghent.
Yeah, I know. Nelson pointed that out to me. Let me see if I can find that. I think I've got that. I think I've got that. As a matter of fact, it's what you need is the original, because the Treaty of Ghent is actually written in script, and in there, they spell it differently, and most people don't know.
I got a copy from National Archive, certified copy.
Yeah, exactly. That's what he did too. Well, the one I've got is a typed one. The one he showed me was I think I searched for it on Google. He showed me how to search for it on Google. Let's try that here. Yeah, here, I'll share it. I got this. This is actually on Wikipedia. So this is the front page of the Treaty of Ghent. And if you notice, the United States of America. And D is capitalized, which means under the Articles of Confederation. Anyways, that's the front page of the Treaty of Ghent. And it's and there's anything I've learned is that capitalization is everything. And
I posted the one from NARA just now.
Okay, NARA. Okay. So anyways, let's go to yeah, this is the motion for leave to file my second amended demand for relief. You didn't post it on my group. You must have posted it on the main group, eh? Anyways, this is the motion for leave to file a second amended demand for relief. And so there's an emerging dictatorship by these Roman cult bar members who assault you with the Commerce Clause under Article 1, Section 8, Clause 3 in violation of Article 1, Section 8, Clause 17. And this is where National Mutual Insurance Company, the boundaries of the District of Columbia expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's why when at the Kavanaugh hearings, I don't know how many of you remember in the Kavanaugh hearings, they asked him, can we go after a U.S. citizen in Afghanistan? And he said, yes, you can. And And under the Commerce Clause, there's no common law, which is a plenary jurisdiction. And it even talks about it in this case. Through their plenary power nationally, which is a plenary jurisdiction, a court's full and absolute power over the subject matter and the parties in the case. It's a dictatorship. Plenary is dictatorship. It's total power, complete power over a particular area with no limitations. This term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. Court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. To call it a contract with the objective of denying common law. And there's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command. And Texas is the same way. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. And then they refuse to do anything about it when you object to it, as described in the brief attached. The Second Amendment demand for relief adds the Board of Disciplinary Appeals because all bar grievances against 94 separate bar members, some more than once, which were dismissed as an inquiry, were appealed to the Board of Disciplinary Appeals, which dismissed every case again. The Board of Disciplinary Appeals are bar members appointed by the Supreme Court, just Hecht, who's already being sued. The demand and file bar grievances against bar members with Purdue, Brandon Fielder, Collins, and Mott, which were all dismissed by the bar and BOTA. The Second Amendment demand for relief adds the State Commission on Judicial Conduct because the demand filed dozens of judicial complaints, all dismissed, with 25 were dismissed on the same day. The State Commission on Judicial Conduct consists of 6 judges appointed by the Supreme Court, which is Hecht, 2 attorneys appointed by the State Bar, subject to regulation by Hecht, and 5 members of the public appointed by the governor, a bar member. The Second Amendment demand for relief adds the Attorney General of Texas, a bar member, because he's in dereliction of his duty to the people. And this is a Kentucky court case. It's true that at common law, the duty of the Attorney General is to represent the king, he being the embodiment of the state. But under the democratic form of government now prevailing, the people are king, so the Attorney General's duties are to that sovereign rather than to the machinery of government. Because the Attorney General is defending these wrongdoers, even when they're being sued in their private capacity, and he's facilitating these tax thieves by turning a blind eye to their activities. The Second Amendment demand for relief adds the Texas House of Representatives Committee on the Judiciary because they're part of the problem. The Second Amendment demand for relief adds a table of contents, and the evidence attached is incorporated into the text as a total of 17 exhibits. The demandant requires this court to grant demandant's motion to file a Second Amendment demand for relief. And here's a certificate of conference. David Tabor and Alyssa Cordova, Purdue, Brandon Fielder, Collins, and Mott spoke with David, who opposed the Second Amendment demand for relief for himself and Alyssa on 27 December. Tammy C. Parker, U.S. Attorney, left a voice message on 27th of December 2024 at approximately noon, and on 30 December 2024 at approximately 4 p.m., stating that if they failed to respond, it would be put down that they opposed. No responses at the time of this filing. Jonathan Elzey left a message with someone who answered on 27 December 2024 at approximately noon, stating that if they failed to respond, it would put down that they opposed. They said they would get the message to him. No response. Scott Grayton, Assistant Texas Attorney General, on 30 December 2024 at approximately 4 p.m. After speaking to Scott, he said he opposed the Second Amendment demand for relief. He's the one that he asked me what the particulars was. And I told him there's an emerging dictatorship. And he said, well, he says he would oppose it then. Anyways, Amanda Cates, Disciplinary Counsel, State Bar of Texas, spoke with Amanda on 2 January at approximately 10:30 a.m. in the morning, and she stated she's opposed. And she didn't even ask what it was. The Scott Grayton, the Texas Attorney General, is the only one that was interested in what it was all about. Christopher Lindsay, Assistant Texas Attorney General, left a voice message at approximately noon on 30th of December 2024 and approximately 4 p.m., stating that if they fail to respond, it will be put down if they oppose, no response. So that's the certificate of conference. And then the certificate of service, I served them all, 7 of them, with this motion and the second amended demand for relief. So the brief in support of it, common law requirement. The Constitution of the United States is dated September 17, 1787, which is still in effect and has never been declared void, and is the oldest written constitution still in effect today, wherein Article 1, Section 1 states, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of the Senate and House of Representatives. And remember, everything is in the words, okay? So legislative powers. And in Article 1, Section 8, Clause 9, it states that Congress shall have power to constitute tribunals inferior to the Supreme Court. And so the Constitution had not, prior to the statement in the Constitution being written, since it was Article 1, provided for a legislative Supreme Court. They could not, without any doubt, be referring to our one Supreme Court in and of the common law, which was already established and active, and the United States in America and the United States of America. It's clear that the Constitution is now setting up another set of courts called legislative courts, and they refer to them as inferior courts, meaning inferior to the already existing common law courts, our one Supreme Court. Article 1 of the Constitution did then and there set up legislative courts inferior to the common law courts, as verified by Article 7 of the Articles of Amendment to the Constitution, wherein it guarantees in suits of common law no fact tried by a jury shall otherwise be reexamined in any court of the United States than according to the rules of the common law. The Supreme Court, talked about in Article 3, establishes a legislative inferior Supreme Court of the United States for the District of Columbia, which is established by an act to establish the judicial courts of the United States, approved September 24, 1789. Even the Supreme Court is a legislative court, so that means it's inferior to the Supreme Court of the United States. And the Code of Law for the District of Columbia, 31 Stat 1189, March 3, 1901, establishes the Supreme Court of the District of Columbia, which is also known as the Supreme Court of the United States. And some of the judges, maybe all, are on both, and the nature of the jurisdiction is determined by the issues being presented. But the only true Article 3 court is our one Supreme Court, a common law court of the people, by the people, and for the people, and was in existence prior to the Constitution. And this is Hale versus Henkel, 1906. His rights are such as existed by the law of the land, long antecedent to the organization of the state. Law of the land is a convertible phrase with common law, and can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. This sets the courts of common law separate and apart from legislative courts, such as this court or the 97th District Court, otherwise being a maritime court, in that any case tried in this court or the 97th District Court can be reexamined by action of appeal. This places this court and the 97th District Court as one of the inferior courts, referred to in Article 1, Section 8 of the Constitution of the United States. Note the difference in a trial by jury in common law as to a trial with a jury in legislative inferior courts. The judge in the inferior courts instructs the jury on what they will hear and decide upon and what they will not. There is no such provision in common law with trial with a jury. A common law trial by jury means the jury conducts the trial. The Northwest Ordinance of 13 July 1787, less than 3 months prior to the Constitution, which had never been altered by common consent or in any way or manner, and presently remains in force. The last words of the introduction or preamble of the Articles of Ordinances, Section 14, state, the following articles shall be considered articles of compact between the original states and the people and states in said territory, and shall forever remain unalterable. And so the importance of this is it defines the nature of federal jurisdiction in federal territory. Was intended to be part of the Articles of Confederation and forever unalterable, and all previous engagements entered into, all debts contracted, all engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. And that's Article 6, Clause 1. Includes the Northwest Ordinance, which is in full force and effect in Texas. The compact agreement is a federal injunction and is forever unalterable even by the legislative Congress or its legislative Supreme Court and its other inferior courts or the administration. It is protected by Article 4, Section 2, Clause 1 of this Constitution for the United States of America, which guarantees the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. That is describing the two classes of citizens, right? Citizens of each state, that's state citizens. Citizens in the several states are U.S. citizens or federal citizens. Article 2 of the Compact Agreement states the inhabitants of said territory shall always be entitled to the writ of habeas corpus and a trial by jury and of judicial proceedings according to the course of the common law. Legislative statutory law is in fact an extension of maritime law. The 1946 Administrative Procedures Act, Title 5, United States Code, Section 559 at Sentence 2, requires the administrative law to be in compliance with and in conformity to the Constitution for the United States of America and the common law, with all its prohibitions, restrictions, restraints, and limitations opposed by its enumerated bounds and boundaries as described in the first 10 amendments. And history is clear that the first 10 amendments were written to the Constitution, were adopted to secure certain common law rights of the people against invasion by the federal government. The Maritime Code, otherwise known as statutory law, being administered in legislative inferior courts, this court and the 97th District Court, as evidenced by the maritime gold braid flag or the corporate seal in the courtroom, also acknowledges that when brought inland beyond the high water mark or the first bridge of any navigable river, they must be brought into compliance with and in conformity to this Constitution for the United States of America and subject to the common law. And this is the Judiciary Act that created the Supreme Court. And it says, saving to suitors in all cases the right to a common law remedy where the common law is competent to give it, which shall also have exclusive original jurisdiction, cognizance of all seizures on land and other waters than aforesaid made, and all suits for penalties and forfeitures incurred under the laws of the United States. And that's talking about the incorporated government. Third, this is 36 Stat 1611, which is the judicial code that was passed in like 1935 or something like that. Third, of all causes of admiralty and maritime, saving to suitors in all cases the right of a common law remedy where the common law is competent to give it. Thus meaning competent. Common law is not extending in reverse of the high water mark or extending to steer or the jurisdiction of the maritime law or to exercise jurisdiction as stated in the Constitution under Article 1, Section 8, Clause 17 and 18, wherein it declares that the inferior tribunal shall exercise exclusive legislation as prescribed by Congress over such district not exceeding 10 miles square, as made by session of particular states and the acceptance of Congress become a seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. To make all laws which shall be necessary and proper for the carrying into execution of foregoing powers, and all other powers vested by this Constitution of the government of the United States or any department officer thereof. Okay, so that's Article 1, Section 8, Clauses 17 and 18. Therefore, all legislative courts have jurisdiction in the District of Columbia only under the Commerce Clause, which is why they use zip codes, which are only in the District of Columbia, and commercial paper / Federal Reserve notes / forced loans, which are only for use in the District of Columbia, 12 U.S.C. 411 and the Gold Reserve Act of 1934 at 48 Stat 344. It's interesting to note that at the federal court here that I go into all the time to file stuff, on the clerk's office, it says that they don't accept they don't accept cash. Okay, that means Federal Reserve notes, and it says that you can go down to the post office and get a money order, and there's a post office manual of 1955 or 1952 that's available. I got it. I downloaded it. I need to do some research on that because what I'm hearing is there's proof in there that all money orders have to be backed up by gold. Anyways, and so they want money orders. They want lawful money. That's very, very interesting. And I think it's because of what's happening with Trump and the military. I think that we're going back to a republic. So we'll see. I don't know. We'll see. That's all I can say. Therefore, all legislative courts have jurisdiction in the District of Columbia only under the Commerce Clause. I already read that. Paragraph 11, legislative statutory inferior courts themselves admitted the validity of the common law court in Strauss versus Strauss. Notice that's a divorce case. 1941, which states every system of law known to civilized society generated from or had as its component one of three well-known systems of ethics, pagan, Stoic, or Christian. The common law draws its subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. Paragraph 12, whereas we learned the law of the land means common law, State versus Simmons, 1884, Justice O'Neill speaking for the court, Taylor versus Porter, at Fore Hill, 140, at 146, 1843, Webster's definition of the law of the land at Dartmouth for Wheaton, 518, which is affirmed by Article 6, Clause 2, which declares this Constitution shall be the supreme law of the land. And Wiley versus Commons, 1851, acknowledges the common law in the Holy Bible from which it came, which is the foundation of the common law, is our God-given constitutionally secured rights. The 97th Congress declared the Holy Bible to be the Word of God by joint resolution, Public Law 97-280, 96 Stat 1211. This inferior legislative court fails to be an Article 3 court. And this is Balzac versus People of Puerto Rico. The United States District Court is not a true United States court established under Constitution Article 3 to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3 of making all needful rules and regulations respecting the territory belong to the United States. This court is required to provide the demandant a Republican form of government, Article 4, Section 4, and as one of we the people, the demandant is a state in this union because we the people are the state and have immunity against these County of Montague corporate thieves under Article 11 in amendment and their bar member handlers. The government is but an agency of the state being the sovereign people. A state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. And that's U.S. Supreme Court, Chisholm versus Georgia, 1793. And a Republican form of government fails to include the District of Columbia Commerce Clause under Article 1, Section 8, Clause 3 because of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square. These County of Montague corporate mafia and their bar member handlers engaged in the theft of the demandant's land with their forced rendition, and the bar members are the most culpable. The individual may stand upon his constitutional rights of a citizen. His rights as existed by the law of the land, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. and their inferior legislative maritime court failed to be a trial by jury and absolutely failed to have anything to do with common law in violation of 1 Stat 77, Section 9A, and 36 Stat 1611, Section 256, Part 3. And it was an administrative hearing that failed to have an Article 3 judge, but was an executive branch administrator, which means any decision was a bill of pains and penalties, which is similar to a bill of attainder and prohibited, because they are inferior legislative courts, which are an extension of the legislature, and there's no Article 3 judge present. Therefore, it's a non-judicial legislative act targeted at property owners. No separation of powers. In 1861, the Southern states walked out of Congress, and Congress ceased to have a quorum and could not conduct business. And on the 15th of April, 1861, at 12 Stat 1258, Lincoln ordered Congress to reconvene under executive authority. And 3 months later, on August 5th, 1861, at 12 Stat 292, while operating under executive authority, Congress approved an act to provide for increased revenue from imports and pay interest on the public debt and for other purpose, which precipitated all of this. And Congress has been operating under executive authority ever since. In 1871, under executive authority, Congress created a municipal corporation called the United States for a government of the District of Columbia, 16 Stat 419, under Roman law. And now there are two national governments, one of which Congress operates outside and independently of the Constitution for U.S. citizens and resident aliens under the Commerce Clause, Article 1, Section 8, Clause 3. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And that's Downs versus Bidwell, 1901. The legislative inferior Supreme Court ruled on a case that Lincoln failed to like, and Lincoln sent troops to the legislative inferior Supreme Court, which resulted in Rule 45, process, mandates. All process of this court's issued in the name of the President of the United States. Therefore, there is no separation of powers, and everything's under the authority of Congress operating under the executive authority. And this legislative inferior court is actually the executive branch operating under Roman law, and all officers of this legislative inferior courts are executive branch administrators with no common law. There is no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command or crimes. The state of Texas is a municipal corporation operating under executive authority that's a subsidiary of the United States corporation domiciled in the District of Columbia, operating under the Commerce Clause, executive authority with no common law. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. Congress passed the Code of Law for the District of Columbia, 31 Stat 1189, March 3rd, 1901, which is now known as United States Code, which all courts, federal and state, operate under. Posterity. This legislative inferior court is operating under the demandant's authority because Will Livingston, who ratified this Constitution for the United States of America on behalf of New Jersey on 18 December 1787, is the demandant's fourth great uncle, which means the demandant is posterity as found in the preamble. And the demandant's entitled to right of blood, and no civil law can destroy right of blood because all the laws of Congress and all the laws of Texas are civil laws. And this is the maxim of law. The right of blood and kindred cannot be destroyed by any civil law. And the court is operating under a power which is derived from the demandant as posterity, and the maxim says the power which is derived cannot be greater than that from which it is derived. And this is what this maxim says right there. Therefore, it's impossible for the demandant to give any of these wrongdoers or their bar member handlers or this court any authority over the demandant. And John Marshall, the chief judge of the Legislative Inferior Supreme Court of the United States, agreed and said it's impossible for the demandant to confer a sovereignty which will extend over him. And this is McCullough versus Maryland. I think it's 1819. The sovereignty of the state extends to everything which exists by its own authority or is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. And the demandant is exempt from these county of Montag thieves or their bar member handlers, not because of any formal conception or obsolete theory, but on the logical, practical ground that there can be no legal right as against the authority that makes the law on which the right depends. So, I mean, we got some home runs here, I think. And that's Supreme Court, Kawanakoa versus Polyblank, 1907. And the demandant requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land. Anything in the constitutional laws of any state to the contrary, notwithstanding, Article 6, Clause 2. Okay, and then it goes to bar equals Vatican, which is 1871 corporation operated by the Vatican. It appears that the bar changed in 1947 because of the Bar Treaty of 1947, which is supposed to be effective in the District of Columbia only. BAR is an acronym which stands for British Accredited Regency because all bar members are appointed under authority of the Inns of Court. Inns of Court, these are certain private unincorporated associations in the nature of collegiate houses located in London and vested with the exclusive privilege of calling men to the bar. And that's Black's Law Dictionary, 5th edition, which is one of 4 law schools located in the city of London, which is owned and operated by the Vatican from the concessions to the Pope, 1213. And this is the concessions to the Pope part of it. We will establish a perpetual obligation and concession. We will establish that from the proper and the special revenues of our aforesaid kingdom, for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael, 500 marks, and Easter, 500 marks. 500 marks, 700, namely for the Kingdom of England, and 300 for the Kingdom of Ireland. And that's the concessions of England. So they're paying the Pope tribute. And the concessions of the Pope, 1213, precipitated the Magna Carta, 1215, because King John was trying to collect revenue to pay the Vatican, as evidenced by Chapter 29, which put a stop to their non-judicial proceedings. No freeman shall be taken or imprisoned or diseased or outlawed or exiled or any way destroyed, nor shall we go upon him nor send upon him, but by the lawful judgment of his peers or the law of the land. And several chapters of the Magna Carta, which they were prohibiting from charging certain fees. And the bar members are here as regents, British Accredited Regency. A regency is the office or jurisdiction of a regent or body of regents. A regent is a person who exercises the ruling power in a kingdom during the minority, absence, or other disability of the sovereign. We, the people, were asleep at the wheel. Because the District of Columbia Municipal Corporation, set up in 1871, called United States, went bankrupt in 1933. It's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent, HJR 192, 73rd Congress in session, June 5, 1933. Joint resolution to suspend the gold standard and abrogate the gold clause, dissolve its sovereign authority, the United States, and the official capacities of all United States governmental officers, and departments, and is further evidence that the United States federal government exists today in name only. And that's Congressional Record, March 17, 1993, Volume 33, and is owned and operated by the Vatican. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And that's Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. as evidenced by the Roman Achaea military staff carried in battle by all Roman commands and planted on all conquered nations, that is sitting on the right side of the Speaker's podium in the United States House of Representatives, and the 2 Roman fasci on the wall of each side of the Speaker's podium. Therefore, all bar members are foreign agents of the Roman cult, the Vatican, here to impose martial law rule for the Vatican. There's 3 kinds of martial law. Full martial law is a declaration of martial law is issued. Troops are put on the streets, used only during wartime, used on a foreign country when actually invaded by a foreign power, or to put down an armed rebellion. Martial law proper is the law of the armed forces. When a captain tells a private what to do, it's enforced by court-martial. Martial law rule is the law of necessity and emergency. Allows the domestic use of martial law powers as used during times of peace. And that's all found in Ex parte Milligan. I think that's the case that Supreme Court ruled on that Lincoln didn't like. But I don't know. I just know it happened. In the District of Columbia only, under the Commerce Clause, which continues to this day. Since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the president may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens. The majority of the people of the United States have lived all their lives under emergency rule. It's martial law rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by a Bras law enforced by states of national emergency. And that's INRI U.S. Senate Report number 93-549, dated November 19, 1973. Do you think anything's changed? Absolutely not. Until Trump. It's maybe it's starting to change now. Anyways, notice here, March 9, 1933, this declared national emergency under the U.S. Senate report. And then you go here to the congressional record. United States is declared bankrupt and solvent, March 9, 1933. Same date. It's because of the bankruptcy. And anyone who hires an attorney is an imbecile. Clients are also called wards of the court. That's Corpus Juris Secundum, Book 7, Section 4. Attorneys, wards of the court are infants of persons of unsound mind. Their rights must be guarded jealously, which is why the bought and paid for court buyers selling her just us in the 97th District Court was operating her star chamber with her forced bar member buddy because she intended to presume jurisdiction. And this is in propria persona. In one's own proper person, it's a rule in pleading that pleas to the jurisdiction of the court must be pled in propria persona, but if pleaded by an attorney, they admit the jurisdiction as an attorney is an officer of the court, and he's presumed to plead after having obtained leave, which admits the jurisdiction. And the defendant's ancestors attempted to prohibit these foreign agents of the Vatican from holding any office of trust, as found in the original Article 13, an amendment taken from 1819 Virginia statutes. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept or retain any present pension, office, or emolument of any kind from any emperor, king, prince, or foreign power, okay, the foreign power is the Vatican, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them, or either of them. Under them is the federal government, either of them is the state governments. But it seems to have disappeared around the Civil War time period, and I think it's because Lincoln was a bar member, and he couldn't hold office as long as that was there. And it has come out that the Vatican was involved in the recent election interference. Quasi-contracts. Texas codes are all bills of pains and penalties. The Texas Penal Code, penalties, because they assault you with a quasi-contract using their District of Columbia Municipal Corporation and Roman law. Assumpsit. Assumpsit is an origin, an action, a tort, was soon transformed into an action of contract, being afterwards a remedy where there was neither tort nor contract, based at first upon an express promise, it was afterwards supported upon an implied promise, and even upon a fictitious promise. Introduced as a special manifestation of an action on the case, it soon acquired the dignity of a distinct form of action, which superseded debt, became concurrent with account, with case upon a bailment, a warranty, and bills of exchange, and competed with equity in the case of essentially equitable quasi-contracts. See, these are all commercial terms. Both in Roman and English law, there are certain obligations which were not truly contractual, but which the law treats as if they were. They were contractual in law, but not in fact, being the subject matter of a fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it. And that's Salmon and Salmon on Jurisprudence, England, which requires the minor estate under 31 CFR 363.6, U.S. citizen or other fiction. Constructive quasi-contracts are based solely upon a legal fiction or fiction of law. So they can assault you with the quasi-contract for their penal action. So a penal, the word penal and penalty in their strict and primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty defines forfeiture to be forfeited for non-compliance with an agreement. It's breach of contract. It's a civil matter. They call it quasi-criminal, but it's really a civil matter. The words forfeit and penalty are substantially synonymous. Penal action is a civil suit brought for recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions. That's why they had to create that minor estate. Okay, that's why they had to do that, so they can assault you with it, so they can populate the prisons and make all sorts of money. That's exactly what's going on. That's why all the wars, okay, when you turn up dead, they get to pillage all the fake money in there and use it to pay off the national debt. Such actions are civil actions, on the one hand closely related to criminal prosecutions, and on the other to actions for private injuries in which the party aggrieved may by statute recover punitive damages. A penal action is one founded entirely on statute, brought with the sole object of recovering a penalty or forfeiture imposed as punishment for a specific offense, while a remedial action is one brought to obtain compensation or indemnity, which is why they use the Roman law of capitis diminutio. Capitis diminutio, meaning the maximum law of status through the use of capitalization, the all block capital letters, the highest, most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage. When he became a slave, it swept away all rights of citizenship and all family rights. Because capitis diminutio is used when they enslave you, and they are Satanists using fraud and deception to sell you into slavery as collateral for their minor estate at 31 CFR 363.6. He, the prisoner, has as a consequence of his crime, not only forfeited his liberty, but all his personal rights, except those which the law and its humanity affords him. He is, for the time being, a slave of the state, which are non-judicial proceedings, because whenever a statute's involved, the fake judge is actually a bought and paid for clerk masquerading as a judge. It's the accepted rule, not in the state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes as a ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency, which is why it's a bill of pains and penalties and unconstitutional, because they have no authority to do anything judicial. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. But the reality is that the bar members do it all the time. The prisons in Texas are populated by quasi-contracts, and the bar members did it in this case. The War of Independence was fought over taxation without representation, and now these District of Columbia bar members are using a Commerce Clause to bring the District of Columbia outside a maximum of 10 miles square, which is talked about in this National Mutual Insurance Company versus Tidewater Transfer Company. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. In violation of Article 1, Section 8, Clause 17, to represent the demandant by force, make false legal determinations for the demandant, that the demandant's a minor estate, that the demandant's an imbecile, that the demandant's a taxpayer, that the demandant is their slave. So then they could tax the demandant. And this is Longborough versus Blake. If it were true that according to the spirit of our Constitution, the power of taxation must be limited by the right of representation, whence is derived the right to lay and collect duties, imposts, excises within this district. If the principles of liberty of our Constitution forbid the raising of revenue from those who are not represented, do not these principles forbid the raising it by duties, imposts, excises, as well as by direct tax? So they force represent you, and that's why I'm going after the fucking bar. And use it as justification for the theft of the demandant's land. And that's about the end of it. And then I got a order. But that's it. So that's the argument. That's how I did it. They're basically assaulting you with the Commerce Clause, dragging you, bringing the District of Columbia outside 10 Mile Square in violation of Article 1, Section 8, Clause 17, so they can assault you with the Commerce Clause. So it's a dictatorship because there's no common law. It's total power, plenary jurisdiction. And they're just nothing but a bunch of thieves. Yeah, don't get me going. You're going to get me going here now. Anyways, does anybody have any questions?
How do you go after the bar? I like that.
Well, I already added them to the lawsuit. I did it in the first amended demand for relief. So the bar is already added. So is the Chief Justice of the Supreme Court, Hecht. And they're trying to get him removed. And so we'll see. We'll see if he gets removed or not. So far, he hasn't got removed.
Glenn, I posted.
Sorry?
Go ahead.
Sorry?
I apologize, Big Blue. You may go, please.
Glenn, I posted in the room a case, Supreme Court case, Bodie v. Connecticut, where it was about a divorce case where charging a fee is denial of due process. Deep dive into due process, and they go really deep into due process.
Okay, where did you post that?
Here at the bottom of the room here in general.
Not in my room.
The general discussion group.
Okay.
I can move it over for you, Glenn.
Oh, that's okay. I kind of like to download that. I think that'd be a good one to download. So, I mean, you can move it over, too, if you want. I don't care. But
You're basically trying to get a divorce from the Bar Association, right?
well, this is one that I'm prepared to take to the Supreme Court, quite frankly. I'm going to break it off in their ass.
I'm just framing it as you're getting a divorce from the Bar Association, and Bodie v. Connecticut is a divorce case.
Oh.
I'm just tying it together.
Okay. But it's in the Supreme Court. That's interesting. And it looks like it appealed from the District Court of Connecticut directly to the Supreme Court.
Pull it up there. Let's go over it.
Okay, well, I'm looking at it right now. So it's appealed from the United States District Court. I need to let's do something here. I want to make a PDF of this. So, okay, now let's go back there. Well, let's share it. I guess I need to share it. Okay, let's make it bigger. There. Bodie v. Connecticut. Yeah, okay. So it's appeal from United States District Court for the District of Connecticut. Raymond J. Cannon, Assistant Attorney General of Connecticut. Appellees. It's hard to say who the appellee is. Bodie versus Connecticut at the Supreme Court. Argued on the 8th of December and then re-argued on so almost a year later. So they had to go back and re-argue it. It's interesting. Assistant Attorney General of Connecticut regarded appellees, okay, so they're respondents. Appellants argued the cause, filed briefs for the appellants. But I'm not sure who's appellant and who's appellee, but the appellees is the Attorney General, so that's the government, basically. With him on the brief were Robert Attorney General William S. Kaplan. Alan Ashman filed a brief from the National Legal Aid and Defender Association, amicus curiae, urging reversal. Amicus curiae is a friend of the court. Urging affirmance were filed by Francis Birch, Attorney General of Maryland. Assistant Attorney General, joined by George F., Attorney General for New Jersey. So there's a bunch of people that are showing up in this thing. There's somebody from Louisiana, Delaware, Nebraska, Nevada, North Dakota, Oregon, a bunch of people. Justice Harlan delivered the opinion of the court. Wow, isn't that interesting? Isn't he the one that did that Downs versus Bidwell case, the dissenting opinion? Yeah, I think he is. And this is 70s, and he did that in 1901? So, damn, he's been there for a hell of a long time. I'm guessing it's the same Harlan. I don't know.
No,
anyways,
it's not the same Harlan.
Must not be, can't be 70 years. Okay, appellants, welfare recipients residing in the state of Connecticut brought this action in the federal district court for the district on behalf of themselves. Okay, so that's the Bodies, right? And it's a divorce case. So both of them brought it. So they obviously didn't fight that much. On behalf of themselves and others similarly situated, challenging as applied to them certain state procedures for the commencement of litigation, including requirements for paying of court fees and costs for service of process that restrict their access to the courts in their effort to bring an action of divorce. It appears from the briefs and oral argument that the average cost of litigation for bringing action for divorce is $60, and the Connecticut General Statutes provides that there shall be paid to the clerks of the Supreme Court of the Superior Court for entering each civil cause $45. An additional $15 is usually required for service of process by the sheriff, although as much as $40 or $50 may be necessary when notice must be accomplished by publication. There is no dispute as to the inability of the named applicants in the present case to pay either the court fees required by the statute or the cost. This is very interesting. So you could use this for any fees. What I did and what I'm doing now is I don't pay the fee, and then they send me an impecuniosity interrogatory, and I'll say, sure, no problem, I'll fill that out when you give me a statutory and delegated authority to require me to get a driver's license, require me to get a social security number, require me to get a bank account, require me to do all that stuff. And then I need a Fourth Amendment warrant that requires me to disclose all that information. And it's like crickets. Never hear another word about it. Anyways, to meet the cost of daily essentials of life and includes no allotment that could be budgeted to the expense to gain access to the courts in order to obtain a divorce. Also undisputed is appellant's good faith in seeking a divorce. Assuming we must As we must on this motion to dismiss the complaint, the truth of the undisputed allegations made by the appellants, it appears that they were unsuccessful in their attempt to bring their divorce actions to the Connecticut court simply by reason of their indigency. The clerk of the Superior Court returned their papers on the ground that he could not accept them until an entry fee had been paid. Subsequent efforts to obtain a judicial waiver of the fee requirement and to have the court effect service of process were to no avail. Appellants hereafter commenced this action in the federal district court, seeking a judgment declaring the Connecticut statute and service process provisions requiring payment of court fees and expenses as a condition precedent to obtaining court relief are unconstitutional as applied to these indigent appellants and all other members of the class which they represent. As further relief, appellants requested the entry of an injunction ordering appropriate court officials to permit them to proceed with their divorce actions without payment of fees or costs. The three-judge court was convened, and that in 1968, that court concluded that a state may limit access to its civil courts, particularly in that instance to its divorce courts, by the requirement of a filing fee or other fees, which effectively bar persons on relief from commencing actions therein. We noted probable jurisdiction. The case was heard, 1969 term, and thereafter was set for re-argument at the present term. We now reverse our conclusion is that given the basic position of the marriage relationship in the society's hierarchy of values and the concomitant state monopolization of the means for legally dissolving this marriage, this relationship, due process does prohibit a state from denying solely because of inability to pay access to its courts to individuals who seek judicial dissolution of their marriages. At its core, the right to due process reflects the fundamental value in our American constitutional system. Our understanding of that value is the basis upon which we have resolved this case. Perhaps no characteristics of an organized and cohesive society is more fundamental than its erection and enforcement of a system of rules defining the various rights and duties of its members, enabling them to govern our affairs and definitely settle their differences in an orderly and predictable manner. Without such a legal system, social organization and cohesion is virtually impossible. With the ability to seek regularized resolution of conflicts, individuals are capable of interdependent action, which enables them to strive for achievements without the anxieties that would beset them in a disorganized society. Put more succinctly, it is this injection of the rule of law that allows society to reap the benefits of rejecting what political theorists call the state of nature. American society, of course, bottoms its systematic definition of individual rights and duties, as well as its machinery for dispute settlement, not on the custom or the will of strategic placed individuals, but on the common law model. It is to courts or other quasi-judicial official bodies that we ultimately look for the implementation of a regularized, orderly process to dispute settlement. Within this framework, those who wrote our original Constitution is the Fifth Amendment, and later those who drafted the 14th Amendment recognize the centrality of the concept of due process in the operation of this system. You know, what I would do is I'd just give her a writing of divorcement. I hereby divorce myself of you. You're free to go marry another man. Make it notarized, file it in the county, and it's a done deal. Anyway, so they wanted to get the state's permission. I'm not sure that I would. Without due process of law, the state's monopoly over techniques for binding conflict resolution could hardly be said to be acceptable under our scheme of things. Only by providing that the social enforcement mechanism must function strictly within these bounds can we hope to maintain an ordered society that is also just. It is upon this premise that this court has 3 years of adjudication put flesh upon due process principle. Such litigation has, however, typically involved rights of defendants, not as here, persons seeking access to the judicial process in the first instance. This is because our society has been so structured. So what they're saying essentially that a divorce is like, you know, it's a right. You know, if you want to get a divorce, they can't really stop you. And And it wouldn't necessarily be applicable in a case where you're suing somebody because, you might win, you might not. And but I would still do what I do is I'll just, sure, no problem. I'll fill out your interrogatory. The impecuniosity form is an interrogatory. It's a questionnaire. And you're having to give all sorts of information that's none of their damn business. Anyways.
Well, all contract, it doesn't matter whether it's divorce or what, is all covered under the substantive due process clause. You can read a case called Errol Smith versus Burlingham on that. So every single contract, it doesn't matter what type of contract, is under the substantive due process clause. And also, you might want to add into your pleading, by failing to execute the laws that I've given here, that constitutes treason against the United States. I put corpus juris secundum. I've got the whole set of them in there, and it gives you all the elements, and it gives you in the footnotes all the cases that constituted levy and war. Levy and war is a failure to execute the laws.
So as you go through this, though, it does deep dive into what due process is in this dissertation that they're doing.
Yeah, that's interesting.
But it's deeper. It's deeper than what you've gotten so far. But anyway.
Can I please get that document you were speaking about, please?
I posted in the general room. And even the the $60 to pay to get who's echoing? The $60 to go to tax court. Tax court has rulings based on Bodie v. Connecticut about the fee, the $60 fee to go to tax court to get into tax court. There was even a waiver based on Bodie v. Connecticut to not pay the $60 fee to get into tax court. So it's not just about divorce. And it's not a divorce. It's called a dissolution of marriage which is a corporate type structure, dissolution of marriage. But anyway.
Right.
Okay, there's my question. I heard that, and I seen it between the outlines, the lies. Do I need to divorce myself from the state? I've never been married, so they don't have that, third wheel to the weird thing, bizarre love triangle. Because once you get married, you have a third wheel, and that's the state because you can't handle it, and they do take over your children. So I don't
there's
have
no disclosure. There was no
contract.
It was void. There was no disclosure. They didn't fully disclose all the elements of that marriage license or whatever.
But I don't have one to begin with. But do I still need to perhaps create a dissolution of an alleged marriage because they marred my carriage and I'm already married enough?
Well, if you want to be married, what I would do is I'd call it joined in holy matrimony, and so then the state isn't mixed up in it. But if you want to do that, it's up to you. That's the way I would do it. If the woman's going to have the babies, I mean, they always, they're the ones that wind up having the babies. And if there's going to be kids involved, then the guy needs to make some sort of commitment. And if you want that, then I don't have a problem. I got 3 boys and 2 daughters, and 3 sons and 2 daughters. And I love having, that's during that time in my life, it was wonderful. And so I didn't mind being there for my wife during that time period. And she's a great mom, and she makes beautiful babies. And so she deserves some help and assistance for all that. That's a huge job, and it's very expensive. And so I didn't mind, being there to help out. I guess that's something everybody's got to decide for themselves. But I think that I don't have a problem. But if I was to do it again, I did all that stuff before I knew what I know now. If I was to do it again, I would have it'll be joined in holy matrimony. and there'd be no government preacher there, and we'd make up our own vows, or we'd have someone that's not a government preacher. We'd still invite a bunch of people and have a book to sign in, and I just make a package of paperwork and record it all in the county. And then the government's not involved. You're joined in holy matrimony, and then if you want to separate, then you just give her a writing of divorcement, and she's, it's done. You don't need the government involved. People think the government has to be there to be involved in this stuff, and you don't need them involved. And that's the problem. People expect the government to do things that governments aren't intended to do. That's my opinion.
Edward VII and the Duchess of Denmark had a marriage treaty. Sovereigns have treaties. So if we're sovereign, we would have a treaty between the fem sol estate and the homme sol estate, if we're truly sovereign, and have our own marriage treaty, just like Edward VII and the Duchess of Denmark.
Yeah, I don't see a problem with that. Anyways, there's I see that Scallion's future maps are here. Anyways, does anybody have any more questions or anything?
Yes, please. Are you going to share that with the class, please?
What's that?
Please, your case file. Do you have?
Oh,
it
yeah,
available?
sure. Okay.
Thank you.
I can do that here. I'll do it before I sign off, because otherwise I'll forget.
So, are you saying that you are now suing the bar? Well, first I need to get my property back, first and foremost. But they forced her to get enrolled into a public school. Ooh. And now, would that be grounds for suing the whole Board of Education and all their board members and everybody for forcing that? I don't know.
Forced you to enroll in public school? Yeah, I'd definitely sue them over that.
And they also, it was impossible for me to get a food card. All cap name came for, I don't know, some kind of, I guess it was for kids and the children, keyword their children in their school system. And I guess each one, but it came in my all cap name. So they ran my number for that. I called on it and they said, oh no, every child got one. And I said, oh, okay. I was just concerned to make sure it wasn't fraud. And I just played it off like that, because I don't want to get into it with the lady. And it came in my all cap name, so it's frauds and swindles, forced contract. What was that word you used? Subsidiary.
Yeah. You have to understand that something like that is a privilege. If you're getting a food card, that's a privilege from the government. And so what was that other case you were mentioning that says that all is a denial of, you mentioned in related to this Bodie versus Connecticut, the filing fee. There was another case that said, you said that there was was a violation of due process of law. Any fee, like what about affecting service? Should you have to affect service?
Notice is common law due process, right? Notice, an opportunity
Right.
to be heard. So yeah,
Due process of law. So what was that other case you were talking about?
I'll have to go look at my notes for the tax court case about the charging of fees denial due process to get in the tax court case as well, and it's based on Bodie.
Okay. Yeah, I'd be interested in knowing that. As far as trying to get a food card, that is for the lady that was speaking. That's a privilege. You're getting a benefit from the government. You probably had to give them a social security number to do it. And so then that's definitely a privilege. And so then you got to understand that there's a contract there for sure. But the thing to understand, as I try not to take advantage of any of those so-called benefits, because they're really not benefits, and so I just stay away from all of that stuff. There's a Supreme Court case from 1873 called U.S. versus Carlisle, where the Supreme Court said that everyone and everything not privileged is sovereign. And that's when they start hitting me with, the sovereign citizen thing. I hit them with that back, and I tell them that everybody's sovereign. So how come you're not sovereign? Oh, that's right. You're a government employee.
Two things, Glenn. One regarding sovereign citizen. Have you seen what Eon dug up regarding Public Law 67 of May 3rd, 1940, 57 Stat 178, that Congress declared the people were sovereign citizens, and it's called the I Am an American Day. Have you seen that?
I saw that. I've seen that, and I was going to bring that up too. Other thing.
Let me tell you one other thing, and back to the due process about not having to pay the fee or any fee. Among the historic liberties, I put it in the chat too, as well, in your chat in the We Are Law with the treason document. But it says, among the historic liberties, not privileges, protected by the due process under the United States Constitution is the right to be free from and to obtain judicial relief for unjustified intrusions on personal security. And that's personal property as well. So that's 1980 case. So
now, what's that case?
I put it in the chat. It's in pink at the very bottom of that sheet that's got food shit all over it.
Okay.
You see it?
I see it there.
At the very last section. But the other sections are good too. It's the unconstitutional conditions doctrine. And then that law from 1798 tells you that Congress couldn't even take arms, No tax collector could take arms. But if you read treason and you understand the treason, the Corpus Juris Secundum document that I put in there, I'm telling you, failure to execute the law. They're failing to execute the law. That's levying war against the United States.
Right.
So, anyways, I concede.
Yeah, good. Thank you. I guess that's about it then, unless somebody else has something.
Also follow up. So you're sending this in, or you have sent this revised?
Oh, I filed it already. That was it. I was going to upload this. I'm going to upload the Word files for this. The Word files are something you can manipulate, and so that's good that you reminded me, because I was sitting there thinking, what was I going to do? There was something I was going to do, and I couldn't remember.
You're not going to get off that quick. I have bad jokes tonight. Remember?
Oh, okay. Well, bad jokes are good. You've already heard my lawyer joke.
Yeah, I know, a couple of times. So we don't need to hear that bad joke again. It's drilled in. It's drilled into my head. But I always tell that one when I'm put on the spot to tell a bad joke. Like that one in the why do my dogs have friends and people don't? That joke is pretty common too. But no, if anybody doesn't have any other questions about the case, so I'll ask my question last, because I have further questions about that before bad joke time. So, but this is awesome how you're continuing on with this case and really staying, on them. You're not letting up or, letting it go by the wayside like they want you to do. So
no, this is one that I think I gotta do something about it. I think I got them by the short and curlies. I think I have a sympathetic judge, and I'll take it to the Supreme Court. I got this common law judgment, and if worse comes to worse, I'll just get a common law judgment against the bar, and then they'll really be fucked. But no matter what, it's never over till I say it's over. So, okay, I uploaded the motion and the brief for the motion for leave to file a second amended demand for relief, and then the brief. And I can file the actual, I think I already uploaded the Word file for the second amended demand for relief. Yes, I did.
As I'm reading this demand for relief, I don't see what relief you demanded. I mean, I see where you made all the statements, but I don't see the actual relief demanded. Am I missing something?
Well,
Yeah,
what's your which one? The motion and the.
I'm looking at it says motion for leave to file second amended demand for relief.
Right.
What relief? I guess I didn't see.
Well, the motion is to ask permission, okay? Because under the rules you can do the first one, but the second one you have to get permission. And so the motion is to just ask permission. That's all it is. The second amended demand for relief is the actual where I'm telling them what relief I want. And there's a whole section. There's probably about 5 or 6 pages of relief that I require. Okay, it's not I'm begging or anything like that. I require it, and so you go to the second amended demand for relief. It's already been uploaded. It's the actually second amended counterclaim is the name of the file, and I took a document that was named a counterclaim and I just manipulated it, and I never changed it. But the title of the document is if you look in the document, open it up, it'll be a second amended demand for relief.
I see.
So you gotta, it's like about 60 pages. So, and there's about 17 pages of exhibits. So the last pages are before those exhibits. But that's where I want the relief. That's where I actually tell the court that I want the bar disenfranchised and removed or banned from Texas, and that kind of stuff.
Okay. Well, thanks for sharing.
Yeah, well, it's a networking thing, and I don't know everything. And so I appreciate the stuff that you just offered. You had some valuable stuff there. And so I've got some more ammo that I can use in my cases. And it's a networking thing, right? Nobody knows everything. So, Lori, are you going to give me one of your jokes now?
Okay, only one, because I got it off a website for safe folks.
Give me however many you want to give me.
So we're safe.
Give me however many you want.
Okay, I got 3 here that are pretty bad, so hold on tight. Okay. Oh God, now I wrote them down so bad I can't even relay them. No. Okay, no, here we go. Okay, that one's written down bad. I can't read it. Okay. Why did the tomato blush?
Good question. Why?
Why did the tomato blush? Why was the tomato blushing? I know. This is real juvenile. Because it saw the salad dressing. Come on, that's funny. There you go.
That's corny.
I think I can relay one more here. Okay. Did you hear about the factory that burnt down in France? Or that exploded in France?
No.
Has anybody heard about that? All that was left was the debris.
Debris?
The debris, the debris cheese.
The debris. Okay, yeah. Yeah,
Brie
brie.
cheese.
I love brie cheese. That's
I know,
like,
that's my favorite, right? It took me a
oh,
while to get that one. Okay, now I think I can relay one more. What do you call a cheese? Oh, what do you call a cheese? Oh, what do you call a cheese that isn't yours?
Nachos.
Oh, somebody told nacho cheese. Great nature, you caught on to the answer on that one. Good job.
Hey,
Nacho
Glenn, real
cheese.
quick,
Nacho cheese. There you
I
go.
just wanted to make sure. Have you read Poindexter versus Greenhow?
Poindexter versus what?
Greenhow.
I haven't seen that one.
Okay, well, that's a great case. It distinguishes between the state and the government of the state. Okay, the same thing for the United States, and then it was a tax case, and what it was is just to give you a brief overview. I'm gonna put it into the chat, but Poindexter sued Greenhow, which was a tax collector, which had offered him the bonds. Okay, but he sued
Poindexter versus who?
Poindexter versus Greenhow.
Green? How's that spelled?
I just put it in your section in the We Are Law. Okay.
Okay,
You
I'll
got
look.
it. 1885. But just to give you a background of it, it was a law passed by Congress, Virginia State, in this case, and Poindexter sued Greenhow because he offered Greenhow a coupon from a bond that he bought from the state. Well, the legislature changed the law and said, "Oh, you just got to go to court to get refunded for the bonds," and so the Greenhow wouldn't accept Poindexter's coupon, and so Poindexter sued Greenhow personally. Okay, and so in that case, they go through and articulate in stunning detail of how Greenhow doesn't have immunity or is not protected by this law that Congress passed because Congress could pass no such law. Okay, and Greenhow and Greenhow was liable personally. So it's a great tax case. It's a great case to see the distinction. They draw the clear distinctions between the state and the government of the state, and that it doesn't matter that Congress passed a law. If it's an invalid law, you got to show your support of how you are acting under this law, so it's just a great case that if you haven't read it, you need to read it.
Okay, sounds good. I appreciate it. Thank you.
All right.
And that's the thing is that I network with Randy Kelton too, and matter of fact, Randy suggested I do a motion for summary judgment, and I think that's a brilliant idea. So that's what I'm going to be doing too. Anyways, Lori, what else you got there?
Okay, one last one. Thanks for bringing that up, Dan. I'm glad my bad jokes helped you recall that. Hey, so did you hear about the restaurant that opened up on the moon?
Open up where?
Up on the moon.
On the moon? No,
Yeah.
I didn't. I can't say I did.
It has great food, but no atmosphere.
Yeah, right. I'll bet. I just put on here a website. Maybe I'll put the link to it. This is a website that talks about those fires in California, and they're arresting a bunch of people. There's the heck. Let me think.
That came to mind because they're getting dollar for dollar for recoupment costs on all of their loss, where Maui and Paradise only got offered a $750 loan or something. So
it says here that According to inside sources, Los Angeles is currently experiencing are not out-of-control fires, but active terrorism involving 180 people engaged in arson so far. And let me just, this is actually, so I have information now. One of friends has a brother in the police department that kind of high up, and he said that they've identified over 180 people who are responsible for these fires and actually active terrorism. And so, like, there's some of these, there's some videos here I can play. Let me play this one. Yeah, that one doesn't have, but this one here, look at this. They catch this guy. This is Fox LA. They catch him. They did a citizen's arrest, and the cops come. Be careful, people are starting fires in Los Angeles.
Are they citizens or are they illegals, infiltrators?
Well, I don't know. That's not coming out yet. But they've caught. There's like about 180 people they're finding that are so far. We don't know how many more. But so I can let me. I'll upload this to the group, and that'll give you something to look at, because I think that. This is good stuff to know. We need to be watching our neighborhoods. Who knows what the fuck is going to happen in our neighborhoods? You know what I mean? We all need to be watching, being aware of what's going on around us.
Yes, thank you, Glenn, for that. No matter if they're citizens or illegal.
Yeah, it doesn't matter. I don't care. And they're neck. I'm an equal opportunity neck stretcher.
Right?
Anyways, I guess we're about done then. This will give you guys something to go on. And I appreciate your help with this big blue ocean. I guess Dan is your name. You got some good information. I appreciate it. It's a networking thing. Nobody knows everything. And so we're all sharing information. That's a lot of what I do here is share what I know. And, I don't know everything. I'll be the first one to admit that.
A party was going through foreclosure, and they did the Rule 27 at the U.S. District Court, and the plaintiffs ran away.
Really?
Yeah.
So it got dropped in, obviously.
The plaintiffs ran away. They dismissed.
Yeah, right. Failure to prosecute. That's what you do with that one. Anyways. All right. You guys have a great one. If you can send me the video there, Lori, when you get a chance. No big rush.
Yep. Absolutely. You have a good weekend, and thank you for sharing the update on your case. Look forward to talking to you next week, and I'll be talking to you before that.
All right. Sounds good. Take care.
You too. Bye, Glenn.
Thank you, Ryan.
Thank you.
Great input, Sean, and Dan. Thank you very much for giving.
Hey, Smoking Baby,
insight.
how's your HOA issues panning out?
They're stalled at this point.
Nothing new. No more. No more real party and interest.
They can't take any actions. They don't have They can't overcome the priority lien that's already in place.
Yeah, isn't that lovely? Isn't it lovely?
Yes, it's good to have a mortgage on the property so these little assholes can't steal it. Yep, that's true. I agree.
And